What is IPR?
What are IPR? Basically, intellectual property rights. We have to understand what is intellectual property. So, intellectual property is any unique creation of your intellect or of your mind. Taking Coca-Cola's example,
Architects, interior designers या design professional के लिए IPR की क्या relevance है?
come down to the relevance, I will first have to explain to you what are the different kinds of IPs that apply to architects and interior designers. The first kind of IP that is the most relevant for you is your
We've started a company. So now they name their studio, they design a logo for the studio. What all kind of trademarks does one designer need to take?
So number one is the name. I'll take your example.
Packaging for lace. What other aspects within IPR, again I would say with respect to designers, we need to know apart from trademarks?
So the next key important, in fact, one of the foremost IPs that interior designers and architects should keep in mind are copyrights. Now, what are copyrights?
Doing a project for somebody, like working on the project at site, there is some kind of a dispute. How do we protect our IPR in this case?
First, let's see what does the copyright law says. According to the copyright law, people like architects, interior designers are independent contractors, which means that you retain copyright over the work that you've created, and technically, in order to allow somebody to use your copyrighted work, you have to.
Today's podcast is on intellectual property rights. Yes, IPR as we call it. And the guest for today is Miss Nayantara Malhotra. Her company's name is Ostara Legal, and she's been practicing from past 7.5 to 8 years. हमने बहुत से टॉपिक्स पे बात करी. It's going to be a very, very detailed podcast. And if you want to learn about IPR with respect to architects, designers, interior designers, then this is the video for you. If you're interested in this topic, watch this video till the end. Thank you so much, Nayantara, for being part of today's podcast. And आज हमारे viewers के लिए एक बहुत important topic है, which are majorly architects, interior designers, and people who belong to the design industry. We all know about the word IPR, but इसके अंदर के जो aspects हैं, वो I guess हम designers unaware हैं उसके बारे में. And the idea of calling a specialist like you for today's podcast was learning everything about IPR. मतलब मैं चाहता हूँ आज का टॉपिक अगर हमारा कोई फील्ड में यंग प्रोफेशनल, स्टूडेंट, फ्रेशर ऑलरेडी प्रैक्टिस कर चुका हो, मेरे जैसा जिसको यू हैव एन एक्सपीरियंस ऑफ मोर देन 10 years, it is valid for everybody. It is beneficial for everybody. So again, I thank you for taking out your time and being part of this podcast. थोड़ा सा हमारे व्यूअर्स को बता दीजिए कि आपका प्रोफेशनल बैकग्राउंड है क्या?
Right. Firstly, thank you, Chirag, for having me over. I think what you're doing over here is absolutely wonderful. I think all of us can do with more knowledge about IP awareness, particularly in this country where IPs are not really respected. But we'll, of course, go into that later. Talking about myself, I am Nayantara Malhotra. I am an intellectual property attorney and I've been practicing for the past 7.5 years. I specialize exclusively in the field of IP. I run a firm called Ostara Legal, where I and my team of fellow IP attorneys, which include senior litigation lawyers, senior patent and design attorneys, help clients to protect their IP not only in India, but also outside India.
Great. So I think let's dive into the questions, which I have a long list of questions for you.
Right.
What is IPR?
All right. So to get into what are IPR, basically intellectual property rights, we have to understand what is intellectual property. So intellectual property is any unique creation of your intellect or of your mind. For example, you told me that your brand is Modox. Now, Modox is a creation of your intellect. Hence, the name Modox is your intellectual property. Taking Coca-Cola's example, somebody came up with a unique name, Coca-Cola, which does not have a dictionary meaning. So that name becomes Coca-Cola company's intellectual property. Now, if you look at the shape of a Coca-Cola bottle, it is quite unique. It is quite curvy. It has certain grooves in it. So the shape was also conceptualized by someone.
Right.
So that also becomes Coca-Cola's intellectual property. Now, if we come down to the taste, it is a very unique taste. I have never had a beverage which tastes exactly like Coca-Cola.
Yeah.
Have you ever?
Yeah, no, I haven't. Yeah.
All right. So why is that?
Hmm.
Because that recipe is a secret recipe, and that is a trade secret of Coca-Cola, and that is also an intellectual property. So any unique creation of your mind is an intellectual property. The exclusive rights that you have over that intellectual property is your intellectual property right, which basically means only you are entitled to monetize and exploit your IP. Now, if you find out that there is somebody out there who's copying your trademark Modocs and coming up with a brand
Trademark Modocs.
Yeah.
So trademark falls under IPR.
Right. So trademark or a brand name is essentially what an IP is.
So I would like to cut you here and would ask you that architects, interior designers या design professional के लिए IPR की क्या relevance है?
Right. So to come down to the relevance, I will first have to explain to you what are the different kinds of IPs that apply to architects and interior designers. While there are a number of IPRs that are protected universally, I will only discuss the ones which I deem the most relevant for architects and interior designers. So, as I just mentioned, the first kind of IP that is the most relevant for you is your brand, right? A name that represents you.
So, the brand name.
The brand name.
Okay.
So, that is what essentially a trademark is. So, now a trademark can be a brand name. It can be a unique logo that you would have come up with. So, for example, if you look at the Disney logo, you'll see it is a very curvy logo. So, that entire logo or the font as a whole is a trademark that belongs to Disney, right? So anything that represents your brand, be it a name, be it a combination of unique colors. For example, if we look at the Google color scheme, now if you adopt the same color scheme, basically you're copying somebody's trademark. So a name,
like
a logo,
same color scheme as in उसके अंदर जो 3-4 colors use होते हैं, red, blue, yellow, whatever colors are used. If I use say the same colors in design and living, so that's infringement of.
If you are copying the same color scheme, you can obviously use a red, you can obviously use a blue, but if you're using the same pattern of colors or a very similar pattern of colors, then yes, that could constitute trademark infringement because that logo is protected, right?
Right. So as soon as we start a company, let's start from the basics, okay? We've started a company and everybody's excited to form a name for their own studio.
Right.
We're taking example of designers only.
Correct.
So now they name their studio, they design a logo for the studio. What all kind of trademarks does one designer need to take?
Right. So number one is the name. I'll take your example. The word Modocs is your trademark.
Okay.
Now, if you have written Modocs...
People actually, our viewers don't know much about Modocs. I usually don't promote my companies on the podcast. So they might be aware about design and living.
Okay.
Yeah.
So then I'll use some other example. I'll use a generic example. We'll use Coca-Cola's example because I think that will resonate with everyone. So the word Coca-Cola is protected. So that is their trademark. Now the logo which you see on the Coca-Cola bottle, which has a specific font or which has a specific typeface, that logo is also protected. Right? Now, if we look at Pepsi, the circular logo devoid of the word Pepsi is also Pepsi's trademark, because now if I start using that circular logo with respect to some other beverage, a consumer could get confused that, this is an extension of Pepsi. So that becomes Pepsi's trademark. Now, certain famous names can also be protected as trademarks. For example, Manish Malhotra. Right? He can protect his name as a trademark. Now, if there is another designer that uses the label Manish Malhotra, he could fall into trouble. Gauri Khan, in fact...
And if that person is not a designer?
If he's not a designer and if he's still
there are many Manish Malhotras in the world.
So if he's offering similar services, allied and cognate services, and if there is a risk of confusion, if a member of the public can feel that the services offered by the second Manish Malhotra could emanate from the original Manish Malhotra, if there is a risk of confusion, that could be actionable. For example, Gauri Khan, she has in fact filed a trademark application for the composite logo mark featuring Gauri Khan. So she's also protecting her name. Right? So fashion designers often do this. I'm also representing a fashion designer who's protecting her name.
Okay. So names ho gaye, logos ho gaye.
Right.
So mostly trademarks yahi cheezon ke liye use hote hain.
This is what commonly people understand trademarks to be, but there are other things as well. Like I told you about the shape of the Coca-Cola bottle.
Right.
That is
That's a
protected as a
trademark.
trademark. That is
Okay.
protected as a trademark, and I'll tell you why. Because if you strip away the Coca-Cola branding and if you just look at the bottle, you will be able to immediately tell that it is emanating from the Coca-Cola company.
Yes.
Because there is an association of the product with the source of origin,
Mhm.
that shape of the bottle is Coca-Cola's trademark. And another interesting
No, that's a very, very
Yeah.
interesting example.
Right.
We've never looked at it this way, but
Right.
that's really interesting. Yeah.
So the catch here is that when you're trying to register a shape as a trademark, or when you're trying to protect a shape as a trademark, you should be able to establish to the court or to the trademark office that when people look at this shape,
Mhm.
devoid of any branding,
Hmm.
they will automatically know where this shape is coming from.
Got it.
So there is one more type of trademark that I wanted to discuss
Okay.
with you. So that's called a trade dress.
Mhm.
So specific
Trade dress.
trade dress.
Okay.
Right. So trade dresses can be of many types.
Okay.
For example, the lace packaging, that can be a trade dress. But with respect,
What in packaging?
so the entire packaging, if you look at the blue lace packet, right? If you look at it as a whole, now if somebody is copying it as a whole, that can become an actionable matter, because that entire packaging can be deemed to be lace's trade dress.
Okay.
Right.
So as in packaging के अंदर जो भी जहाँ text size है, text font है, styling है, and only probably the name Lays is changed,
Right.
and probably that's a other name, but then this thing will fall under
Trade dress.
Okay, trade dress.
So what matters is what is the overall impression of the secondary product.
Okay.
Is it casting the same impression as the primary product in which a trade dress is being claimed? What is more relevant for interior designers and architects are the interiors of a specific space that they are creating. For example, there are certain trademark registrations for some unique salon stores, I believe. So what that company does is that they follow a very specific interior and layout scheme for all of their stores across jurisdictions.
Mostly retail stores do
Right.
follow.
So that can become one's trade dress, and that can also be protected as a trademark.
Even banks have a certain type of specification which they
Right.
follow, and I'm sure that they must be trademarking those designs then.
So it depends on whether the members of the public are able to associate those interiors devoid of any branding with you or not. So if it is unique, if you're replicating the style of this particular studio in multiple studios, and whenever people come over here and they see the same paintings over and over again, that can be protected as a trade dress. So it is not very black and white. You obviously have to look at a lot of facts to assess whether something can qualify to be a valid protectable trade dress or not.
So we discussed about trademarks, and within trademarks, we discussed we can trademark a name for a
Right.
company, we can trademark a logo, we can trademark the shape, and you
Correct.
gave an example of a Coca-Cola bottle,
Right.
and also trade dress, wherein you gave example of packaging for lace. What other aspects within IPR, again, I would say with respect to designers, we need to know apart
Right.
from trademarks?
Right. So the next key important, in fact, one of the foremost IPs that interior designers and architects should keep in mind are copyrights. Now, what are copyrights, or what can be protected as copyrights? So any design plan, any drawing, any sculpture, any work of architecture, any work of artistic craftsmanship can be protected as an artistic work under the copyright law. Right? So I'll break it down. So all of these works that are created by architects and interior designers, or at least most of them, provided that they can demonstrate artistic craftsmanship, can be protected as artistic works under copyright law. Now, what does copyright help you to do? It helps you to retain exclusivity over these plans, drawings, sculptures. It allows you to be the only one who can disseminate these to the public, reproduce them, or give consent to anybody who would want to make a derivative work out of these protectable artistic works.
Okay.
So it basically gives you exclusivity over your creations.
In practical scenario, if you look at a situation, say for example, I'm doing a project for somebody, and the project is started, we've prepared the designs.
Right.
Now we are preparing the good for construction drawings, the working drawings, basically the designs, the concepts, the ideas, probably in 2-dimensional form or 3-dimensional forms. Everything is ready. We've already handed over these designs and concepts to our client. As soon as we start the project, like working on the project at site, there is some kind of a dispute. How do we protect our IPR in this case?
Right. So this is a very interesting question. In fact, there is a judgment of the Bombay High Court that I will actually discuss right now. First, let's see what does the copyright law says. Right. So the copyright law, according to the copyright law, architects, people like architects, interior designers are independent contractors, which means that you retain copyright over the work that you've created. And technically, in order to allow somebody to use your copyrighted work, you have to license it, or you can transfer the rights in entirety by way of an assignment agreement. So as per the copyright law, it's clear that, architects and interior designers, until and unless there is an agreement to the contrary, will retain copyright over these works. But we have to factor in the comprehensive architectural services rules, which say that, which do agree that, the architect owns copyright over their plans. And these plans constitute instruments of service which belong to you. Now, the comprehensive architectural services rules say that the client can only use these plans for the project for which they were made and not for any other project, right? So if you prepared the plan for an X project, the client cannot replicate those plans for a Y project to which you did not consent. Similarly, the embargo is also on any other architect that the client may engage. Right. So there was a really interesting case before the Bombay High Court. What had happened was that an architect had come up with an X plan, handed it over to the client, got payment for the, I think, first 2 or 3 phases. There was some dispute between the client and the architect, and the client handed over the plans to another architect, say Y. Now, X, the original architect, sued the client and Y for copyright infringement. Now, what did the district court and high court hold? The courts held that because the plans were not being used for some other project, there was no copyright infringement. So that is the interesting part. They factored in the comprehensive architectural services rules and noted that the copyright law is a general law, whereas the comprehensive architectural services are a special law. So as per legal principles, a general law always has to give way to the special law, which means that as
special law in this case is
the comprehensive architectural services rules. Right? So because the client and the secondary architect were not using it for a Y project, there was no infringement. But yes, of course, assuming you are not being paid for the plans that you have delivered to the client on good faith, you can always claim damages. You can always go to the court and claim compensation.
That doesn't fall under IPR.
Right.
That's a separate case altogether.
So you can still, file a suit for copyright infringement and see how it pans out, because this was a Bombay High Court judgment. Now, what remains to be seen is how will such a dispute be assessed by other courts as well, because each court has their own jurisdiction, right? So this is something that, would be interesting to see.
In practical scenarios, the number of time a client or say any stakeholder involved in a project wants to replicate or copy your designs for a particular project for a different project is too less, I believe. Usually the problems which arise is that probably the designers are not paid according to their contract, and then either the designer wants to move out of the project, or there is some internal dispute within the project. There is some kind of dispute with other stakeholders in the project, not particularly only the client, and the architect wants to move out of the project. Or probably also scenario 2, which probably happens in many cases, wherein client ही कुछ ऐसा उसके mind में आ जाता है that I probably don't need this guy's services anymore. Probably 50% of payment is done, 50% of payment is left, and he thinks that other people involved in the project can finish the project, and he doesn't really take the supervision of the architect seriously, and he's taken all the drawings, all the intellectual property, and now further doesn't require him or her to visit the site for supervision. So that is the usual case. And then he stops giving the due installments or whatever things which are planned as per the contract. Now if he or she, I mean the client, continues working on the project using our intellectual property, which is our design and concept, and we are out of the project, not because we wanted to be out of the project, because he's forced us to go out of the project by not giving us our due amount, but he's not replicating those designs for another project.
Right.
What rights do we hold?
So, see, at the end of the day, what we have to look at is what is the contractual relationship between the parties. What is it that the contract says? So what I recommend clients is to, draw up watertight contracts that specify that you will only get the plans when this payment is made, right? So it is your duty to do your own due diligence, come up with a watertight contract, and only pass on the plans once you have been paid for it, right? Of course, if there has been a breach of contract, and if you have not licensed the right to use to the client, and if they by chance got the plans prematurely, you can obviously sue for copyright infringement, because at the end of the day, what has to be seen is what did the contract say. Were the license either assigned or licensed to the other side by way of a contract?
You'll have to explain this one more time.
Right.
I couldn't get this.
Okay. So do you want me to start again?
Yeah, please.
All right. So what we need to see first is what does the contract between the client and the architect or the interior designer says, right? When would the license become effective, right? Or when would the assignment become effective? If they have started replicating the designs before the operation of the licensing date, right? That could constitute
what do we mean by licensing
date?
Right.
So licensing basically means when you transfer somebody the right to use your intellectual property, right? So if I am coming up with a plan and you're a client, I may want to give you a license to use the plan. Or what I would want to do, subject to the agreement, is that I would want to transfer the entire ownership of the plan over to you. So, right, we'll have to see what does the agreement say. Was the right to use license to the client or not? Were the rights assigned to the party or not? Right? If the rights were assigned, and if it is only a matter of payment, so that becomes a separate issue. Right? So
if it's a matter of payment with respect to the work we've done, then it's not IPR.
Then it's not strictly IPR. It is instead breach of agreement, right? IPR protects your ability to restrain somebody from using your IP. But if you've already transferred the right to use, right? Or if you've already transferred the right to own, and at the end of the day, only the payment issue is a bone of contention, then it will be more of a breach of agreement, right?
But don't you think, Nayantara, that mostly it's in our scenario, it's a breach of contract with respect to payments? Because usually what happens is that if everything is going smoothly, nobody usually copies it for another project, as I said. So it is usually about 90% of the time, I guess, it's payments related issue only. And as you rightly said, which is absolutely spot on, that one should release their drawings or any form of intellectual property with respect to stages of payments which are mentioned in the contract. But the sad part is that doesn't happen usually, because one pre-plans certain things which are to be done at site. So say, I'll give you an example. If say for electrical drawings are required at the site, but it's not that after releasing the electrical, until the time the electrical drawings are being executed, the studio is not working on any other drawings. We are working on 5 other drawings. So probably the drawings have not been released, but our manas for our staff, ourselves, are already being dedicated, spent to that project, for which we sometimes architects don't get their remuneration. So in that case, and if they lose the project, in that case, they feel cheated. That they've been working for so many manas on the project, and we're just out of the project. So in that case, as much as I can understand, IPR has a lesser role to play.
So
I'm sorry to ask you this question again
No,
and again in
it's
three
okay.
different ways, but this is a major, it's a pain which people in our profession face.
I'll pose a question to you.
Okay.
So, assuming you have prepared the plans, you have put in the man-hours, but if you've not transferred those plans to the client, then it's not breach of intellectual property, right? Because they are not using your intellectual property to begin with, because they don't have in their hands your plans. Right. So that is not a breach of intellectual property, which is why it is very important to focus on advance payments. And I think the dispute that you're talking about, or the issues that you're talking about, they span across industries, even in our own field. So what we focus on is getting into a contract first, right? Where we say that we will only do this work provided we are being paid on a time spent basis, right? So which is why watertight contracts become very important, right? Assuming you have shared the plans on a good faith before the execution of the contract, and then your client tells you that I don't want to engage with you further, and
that's a very interesting example,
and there has been no agreement that has been signed between you or the client which allows him to exclusively use or which allows him to use your plans, then that can constitute intellectual property. So that's why I'm saying that we will have to look at each dispute. We'll have to look at all of the facts surrounding each dispute to be able to comment upon what sort of remedy will be offered to the client.
Got it. So this is about copyright law,
right?
So copyright law is comes into play as soon as a design is made, or is there some kind of documentation we need to do?
So copyright comes into existence as soon as the work is created. So for trademarks and copyrights, registration is not mandatory, but it is advisable, because when there is a dispute, how do you establish that you have a copyright over it? Of course, you can show your internal records, you can show the date on which you created the plan, you can have timestamped documents, but a registration certificate is the best piece of evidence. But yes, having said that, registration is not strictly mandatory, but it is strongly advisable.
So registration with respect to trademark?
With both, with trademarks and copyrights.
So what kind of registration are we supposed to do for plans or three-dimensional designs or two-dimensional, whatever kind of designs we prepare within studio, say for presentation purpose, because the first stage is presentation, and that is the most critical stage,
right?
So what kind of trademark or copyright?
So I'll talk about the theoretical aspects of registration first, and then I'll move on to the practical aspects, because it's not always practically possible to get a copyright registration for each and every presentation that you're preparing, or each and every plan that you're preparing, right? So when I speak of registration, there are designated IP offices in India whom you can approach to register your trademark as or your copyright as your exclusive intellectual property rights, right? There is a whole process that is involved. I won't go into that. That might become very boring to our viewers. But you would have seen the TM and the R within a symbol, R within a circle symbol, right? So that R within a circle symbol indicates that you have a registered trademark. But with copyrights, as I said, copyrights come into existence as soon as the work is created. And you won't always have time to, go to the copyright office before each presentation to get a registration, because registration also takes a few months. It's a few month long process each time, right? So which is why what you should always do is that you should always include a copyright notice in your presentation, clearly indicating that the contents, the original contents of these presentations are subject to copyright and you own the copyright on them. Now, if somebody is misusing your presentation, if somebody is misusing your plan, they can always be held liable for copyright infringement.
And even if you are not into a formal contract, this particular inclusion within our presentation safeguards us from further legal issues.
Correct. This should always be included, right? A copyright notice should always be included in your presentation because it also makes the other person aware, right? You might be aware of what intellectual property rights are, but your client may not be, and he may feel it okay to copy the original content
Right.
that you're putting out.
Right.
The rider over here is that in order to claim a copyright in anything, it has to be an original work. If it is copied, then it may not be subject to a copyright protection. So as long as your artistic work is original, you will own exclusive rights in that copyright.
I'd like to ask you a interesting question here, which I feel is very interesting, is that aajkal people get inspired from the internet. There are a lot of projects, probably international projects, whose pictures are on the net, and then we do get inspired from those pictures and then create our design. It's not that every house, every building which we are designing is actually the entire designs are original. The designs are never original these days, because we have so much option on the internet to get inspired from. Ultimately, the product, the room, whatever the space, comes out absolutely different, because it's an amalgamation mixture of a lot of inspiration. Okay, it's not just you see this picture and replicate it. But I would not say that everything is original. So how does one protect that because you specially said that the designs need to be original. They are many a times not original. I'll give you one more example before you answer this question. Say we are designing a room for somebody. Probably the bed back is inspired from a certain image. The TV units are inspired from a certain image. The wardrobe is inspired from a certain image. The door is inspired from a certain image. So one space, one hall, one room has a lot of elements, and each element is inspired from certain project or certain image, probably Pinterest, because that's most common app which we use for inspiration. So the whole project is inspired from certain things. So then that room does not it's not original. Right. How do we work in that case?
Okay, so there are a few things that I would like to discuss over here, and yes, I do agree with you. It is a very interesting question. Now, whenever we look at any work of creative expression, you will always see that it is inspired by somebody else or inspired by something else. If I take a generic example of movies, the style or the art direction or the way a movie is made may also be inspired by another movie, right? I think the film Joker was inspired by another Robert De Niro film, right? So what matters is if the end product is just inspired or copied, right? So whenever a person who is comparing these two copyrighted works or these two works is able to see that the secondary work is copied, right? There is not a lot of original thought that has been put into it, and the second product ends up looking closely similar to the first product, that would constitute infringement. But yes, this is always determined on a fact-to-fact basis, because it will also have to be seen whether the first product is by itself original or not.
Okay, yeah.
Right?
Absolutely.
Because only the owner of an original work would be able to protect their work against somebody else. So copyright law allows for inspiration to be taken, but it does not allow you to directly copy somebody else's creative works.
Got it.
Right?
So probably some kind of tweaking we designers must do, rather than directly copying or getting inspired, because that is further going to safeguard us only.
Right. And there should be considerable amendments. So slight tweaking, just altering the arrangement by a very small margin would not render your product to be original. What will have to be seen is whether the secondary product is significantly different from the first one. Right? There is also a concept of derivative works in copyright. Okay. For example, if there is a book, now I want to translate that book. If I seek permission from the owner of the original book to translate that book, then I would own a copyright over the translated copy. But if I am doing that without authorization, then that would amount to copyright infringement. So even if you are getting inspired by someone, the question is, would you be able to make material amendments to it to render your final product into something else? Or would you have to go back to the original copyright holder and seek consent from them to, adapt their work into something else? That is one thing. Then the third case is with respect to outright copying. In fact, there was a case before one of the high courts. So there is a company called Countrywide Promoters. What they did was they got renders of a specific project made through a world-renowned company, and they paid them a huge sum for it. And they became exclusive licensees of that artistic work, that is the renders. They saw on Instagram that a competitor was using an image of their renders for an entirely different project. So that is direct copying, right? They haven't obtained any consent from Countrywide Promoters to copy or use their images. So that was a case of copyright infringement. But when there is only a slight inspiration, and when you're able to see that the final product is entirely or mostly different from the original work, then that should pass the muster of the copyright law.
Got it.
Right.
So we discussed trademarks.
Yeah.
We discussed copyrights in detail.
Right.
I have a couple of more questions for you for copyright. But before we move forward, I'd like to ask, is there any other kind of IPR we need to be aware of?
So there are a few more. So number one being designs. So designs protect the aesthetic appeal of a product. For example, if there is a uniquely designed fire pit, right? The unique design of the fire pit can be protected under the design law. The only catch is that in order to be able to protect a design, it should, number one, be original, it should not be copied, and it should not be disclosed to the public, and you need to have a registration for it. So when I say that it should not be disclosed to the public, that means it should not be available in the market before you file a design application for registration before the designs office. So unlike trademarks and copyrights, to be able to protect a design under the designs law, you need a design registration. Of course, after you file a design application for obtaining the registration, you can put it out in the market. But yes, that is the catch. So to summarize, basically, designs protect the original aesthetic value of a product. They do not protect the functional aspects. Now, if I take the example of this particular glass, assuming these grooves are unique to this glass and these cannot be found anywhere else in the world with respect to any other glass, the owner or the manufacturer of this glass company can actually protect the unique designs, because these grooves don't have any functional aspect. It could be a plain surface as well, and it would have worked equally as well as this glass, right? But because these grooves or these dents add some aesthetic value to this glass, these elements can be protected as designs.
Okay.
Right.
So if briefly, I would like you to differentiate between copyrights and design.
Right.
Do we call this a design law? It's a design protection law. What do we call it?
It's called the Designs Act of
Designs
2000.
Act, okay.
And the copyright law is governed in India by the Copyright Act of 1957.
Okay.
Now, both copyright and design law protect the artistic elements. But the unique catch is that if there is an artistic work which is applied to an article through an industrial process more than 50 times, it loses its copyright protection. So to break it down, I'll give you an example. We can use the example of the wallpaper that we have behind you, right? If we look at the wallpaper, it is a painting, which means that it qualifies to be an artistic work, right? Now, but this painting, if it has been applied to the paper, that is an article, through an industrial process more than 50 times, on the 51st production or on the 58th production, it will lose the copyright protection. And assuming if you don't already have a design registration for it, and assuming if you haven't already filed a design application for this artistic work,
before it was copied 50th time, for the 50th time.
Right. So, if you don't have a design application or a design registration, you wouldn't be able to claim any rights in the design as well, right? So that would mean that this is a work that could be copied by anybody, because you would have lost your copyright protection and because you won't have a design registration.
So we've lost our copyright protection because it's been copied more than 50 times.
Because it has been reproduced more than 50 times using an industrial process, right? So the
and the design registration has not been taken.
Yeah, correct.
So this makes me think about the artworks which we usually use in our projects. If they are not original, what kind of law do artworks have with respect to paintings we install? Because we
Right.
do a lot of paintings also when we do houses for people.
Right.
And sometimes there are clients who cannot afford original paintings of, you know, these big artists, say Ravi Verma and all of that.
Right.
So how do we, you know, if we are replicating those artworks, so are we, you know, infringing on these laws?
So it will depend on two factors. Number one, has the artwork lost its own copyright protection? Because in India, an artistic work will be protected for the entirety of life of the author,
Okay.
plus for another 60 years. For example, if I painted a painting today, right? I am 30 right now. Assuming I pass away at 70. Right. So when I pass at 70, the copyright will subsist in my painting for another period of 60 years, after which it will pass on to the public domain. So if you're replicating copyrighted works which have passed on to the public
So
domain,
after the artist dies,
right,
so
plus
60 plus 60 years.
Yeah.
Okay.
Right. So assuming that the copyrighted work has passed on to the public domain, and that's when you're reproducing the painting on a wallpaper or on a mural or on a fresco, that is fine. But if you're reproducing the painting of a copyrighted work in which a copyright currently subsists, then that constitutes copyright infringement. And in fact, if the owner of the copyright does end up getting to know about your usage of that artistic work, they can send you a legal notice. In fact, I am aware of such a dispute. There was an office which was using an artistic work, and they did not know that, you know, somebody else owns a copyright over it. They had bought the piece of artistic work from a third party, and they ended up receiving a legal notice, and then they had to take down the artistic work from their office.
Okay, got it.
Right.
So this brings me to another question. Pre-execution, during execution, and post-execution. Do laws change?
Laws,
and I'm purely speaking with respect to our industry, design and construction.
Right. So IP laws are applied uniformly. They are not industry specific. The laws don't change rapidly. We are still following the Trademarks Act of 1999, the Copyright Act of 1957, the Designs Act of 2000, and the Patents Act of 1970. But yes, amendments do occur from time to time to factor in the developments that are going on in the society.
Okay.
The rights holders really don't have to bother so much about amendments, because these amendments are generally in their favor, except of course when the price of filing trademark or copyright or design or patent applications are increasing to factor in the, you know, changing economy. But yes, people don't have to worry about laws changing pre-execution or during execution or post-execution as such.
Okay.
Right.
I'll give you an example now. We'll again move towards a practical example wherein we are involved in a project. Now, what happens is,
I also have to discuss patents and trade secrets. Will we come to that afterwards?
Yeah, we will.
Okay, all right. Okay.
So these are fourth and fifth, right? IPR in the fourth and fifth point.
Right.
So I would also like to ask you another practical, your take on this practical example, wherein we're involved in a project. Now, again, a dispute arises. Okay, whether it is between me or the client, I'm taking myself as an example, being the architect of the project, or between me and any other stakeholder in the project. And for whatsoever reason, I quit the project. Now, what happens is my drawings are being transferred to the contractor or any other stakeholder in the project. Again, I would like to ask, what kind of protection laws are there wherein I can stop another consultant on board from using my designs? And similarly, you know, vice versa. For example, I'll give you another example and then you can answer both questions. Probably the answer would be the same. If many times, you know, clients approach me and they ask me to design their project, and when I look at their plans, sometimes it's quite evident that a professional has already worked on those plans. Probably an architect from whom they've taken basic concepts or basic layouts, and probably for whatever reason they are not satisfied, not moving forward with that architect or designer, and they approach me. how do I safeguard myself that unknowingly, I start developing from where the previous architect left.
Right.
And unknowingly, probably I might change the entire thing, but say I don't change certain things and I start developing from where he or she left. What kind of things I need to be aware about? These are two questions.
I'll answer the first question first.
Okay.
It again boils down to what stage you are at and what does your contract say. Like I said, if we look at the copyright law, if you've not licensed the right to if you have not licensed the right to use your artistic work to somebody, or if you have not assigned the rights to somebody, if they are using the artistic work without your permission, then that is copyright infringement. I'll go back to the example where you were in some talks with a client. There was no executed agreement between you. Your intent was to never transfer the right to use or own the artistic work to the client. You only send them a copy of what you were developing in good faith. And that is when they terminated your services, because the understanding wasn't that the client is allowed to use your copyrighted work. There could be a suit for copyright infringement. But assuming you are already paid for transferring the plan, right? And mid work, your services are terminated, like what happened in that Bombay High Court dispute, then we would have to refer to the comprehensive architectural services rules, which say that yes, you own the copyright in your artistic work. But if that artistic work is only being used for the project it was agreed upon and not for some other project, then going by that High Court judgment, there is no copyright infringement. That is why I'm saying we'll have to look at the stage that you're at. We'll have to look at the agreements, which is why it is very important to draw up watertight agreements. And it is very important to record conversations between yourself and the client. So even if for
record
some reason,
as in even in today's time, WhatsApp messages are a record.
Reduce your conversation to writing, reduce it to emails, reduce it to WhatsApp. You can specifically say that I am just showing you the plans in good faith. I haven't transferred the right to use this copyrighted work or assign the copyrighted work to you, right? So when you're in the pre-execution stage, right, when you're simply having conversations, when you're simply brainstorming, when you're not sure if the deal would get concluded or not. So there at that time, if the client is misusing your artistic works, we could sue for copyright infringement. But again, this varies from case to case, and we have to actually look at what the exact facts are.
Got it. Right? And answering my second question.
So coming to your second question, what you should do as a secondary architect is you should do your own due diligence first, right? They say that ignorance of law is not an excuse, which is why what you should do is when a client is approaching you with an architectural plan that has been made by somebody else, you ask them, has the architect consented to use of this particular architectural plan for this particular project? Have them reduce that conversation to writing. Have them affirm in writing to you that yes, they have the necessary license or they have the necessary assignment agreement in place to make sure that tomorrow, even if you get sued, you can always show to the court that you did your own due diligence.
But right? In practical scenario, clients usually do not involve themselves in signing on such things. And it becomes difficult to get such things signed from people that, like an NOC probably. So do you think that a couple of lines can be made part of the contract only, and that also would safeguard you?
So that is also what I was coming to at. When you're executing your own contract, incorporate this in one of the clauses and also add an indemnity clause. So tomorrow, even if you end up getting sued by the primary architect, you can always seek compensation from your client for the expenses that you would have to incur in the lawsuit to defend yourself, right? So you should always seek indemnity from your client. And of course, when you are working on a project, the best course of action or the best way forward would be that you change the entire thing so that there is no bone of contention to begin with. But if the client is insisting that you use that plan, you have to insure yourself, right? You have to insure yourself either through recorded conversations or the best way to do it is through a contract where you hold the client, where you add a specific phrase that where the client undertakes and affirms that he is not violating any copyright while transferring the plan to you for execution.
Got it.
Right.
Again, we discussed about trademarks in the start. Then we went on to discussing copyrights, and we discussed design law. Right? It's called design law, right?
Designs, industrial designs.
Okay. Any other thing which falls under IPR?
Right. So patents are also relevant in the construction industry. For example, if somebody is coming up with a new invention, now that invention could be a product or a process. As long there is an inventive step, as long as there is an inventive step that is involved, right? As long as that product or process cannot be found anywhere in the world, either by way of use or by way of pre-existing patent filings, either in India or outside India, then that unique invention can be protected. For example, if you come up with a new form of concrete that, lends a certain advantage to the people who are using that kind of concrete, that could be patented. Right? So patents are a kind of IP that people in the construction industry could look at. So it could include a unique product or a unique process. And patents can be differentiated from designs because designs focus on the aesthetic aspect, whereas patents focus on the functional
product
aspect.
Or a process.
Right. They focus on the functional aspect.
Yeah, this actually has a great it's a great example as far as, in our construction industry, certain building techniques are concerned.
Right.
Yeah, absolutely. What do you think are the challenges design professionals face with respect to IPR? And I am sure you must have come across a lot of people from our industry also who would have come to you for help.
Right.
What are the challenges you think they face?
So there are many. I'll try to break down as many as I can. The first one would be ignorance of IP law, right? Or ignorance of why somebody needs to get their IP protected. The most common kind of disputes that we see are of trademark passing off or infringement, where somebody's brand name has been copied or where somebody's stylization has been copied. Right. What happens is that you have to look at this from the perspective of an average man with imperfect recollection, right? You and I can differentiate between Godox, but can a average person differentiate Godox from Godoxai or Godoxo? Right? So they can always get confused. So what happens is that architects and interior designers, when they haven't protected their trademarks, when they are not monitoring the space, when they are not monitoring the market for infringement, they end up losing reputation, because it is possible that the copycat is not providing as good services as you, right? And the consumers assume that the copycat is a brand extension of yours. So architects and interior designers end up losing reputation. They end up losing their competitive advantage, and they also end up losing a monetary value of the trademark, right? So tomorrow, assuming you want to sell off your brand, whenever a purchaser is looking to buy a brand, they will look at whether your trademark has been protected or not. Right. Protection would be number one, by way of a registration. And secondly, are you enforcing your rights against copycats? If there are too many Godoxes in the market, why would somebody want to buy your brand, right? So that is how brands also lose monetary value and end up going into the public domain. For example, the word thermos used to be a brand, but because the company did not protect their trademarks enough, the word thermos passed on to the public domain, and now anybody can use the word thermos.
Okay.
Right? So that is how brands lose their value.
How much relevance does social media has in today's context with respect to names, So for example, Design and Living, I'll take the podcast name. Now Design and Living, we own a domain by this name, and we do have a social media handle also. And if tomorrow somebody comes up with Design and Living on Instagram, right, or on any other social media platform, does this make me, and I haven't applied for registration. So does it still safeguard me? If I haven't applied for registration, but I have created this name, I have a proof before the copycat, as you said, on social media handles, or as a website domain.
Right. So, going strictly by what the law says, it is the prior user who will have superior rights over a copycat. But the rider is whether the name is something that can be trademarked or not.
Right.
So, there are a few principles that we have to keep in mind, right? Number one, your trademark should be unique. That is, for example, if I adopt the word sun for an interior design company, how do I differentiate my company called Sun from the multiple other entities that are there across industries that are named Sun, right? So, non-distinctive or a non-unique word like Sun may not be protected as a trademark. The second thing that we need to look at is whether the trademark is descriptive. For example, if I come up with a name like interior solutions or interior design solutions, it is a word that directly describes what I am offering, right? And it is a word that can be adopted by anybody again, right? Interior design solutions directly describe what the goods and services are or what the services are. So how can I preclude you from using this name, right? So secondly, your trademark should not be descriptive. Thirdly, what we would
Okay,
need
so
to...
in our case, design and living is, I believe, a bit descriptive and
I'll
very
come to
generic.
that also.
Okay.
The third thing that we need to look at is whether your trademark is similar to a pre-existing mark. Assuming there was a pre-existing design and living, and you were the subsequent party, you may not have the strongest rights to enforce your name against some other party if it can be shown that you did not adopt the trademark in good faith, that your own name is copied, right? The rider to the first two rules, that your trademark should be unique, it should not be descriptive, is that if they have acquired distinctiveness by virtue of use. I'll use Apple's example. Okay. Now, Apple is a very non-distinctive word. Technically, anybody can use it, but because Apple has been using the term Apple for such a long time, now whenever somebody says Apple, mostly the gadgets come to our mind. The fruit comes to our minds later. So that means that the word Apple has lost its original meaning. That is why we can say that because owing to the long and extensive and continued use, the trademark can be protected. So tomorrow, assuming there were copycats out in the market which were copying design and living, we would have to see what is the extent of your use. Does the public exclusively associate a trademark like design and living with you or not? So that is what would have to be seen.
So Nayantara, design and living is a little general. It's a general, I would say, name. If I take example of Modocs, it's a bit specific, you know. So in if I haven't registered the name Modocs as in trademark, I haven't taken the trademark for the name, but I have a social media handle. I have a domain by the name of modocs.com, and somebody else, you know, uses this name Modocs and gets it registered.
Right.
And I haven't registered it. So legally, what chance do I have to win over the trademark fight?
Right. The first question, assuming you were my client and we were encountering such a dispute, my first question to you would be, what does Modocs mean? Does it mean anything?
Yeah, the full form for Modocs is modular box.
Modular box.
It's a steel structure. It's a company which deals in steel structures.
Okay. And but we cannot find a meaning of this word in the dictionary. It is a portmanteau that you would have come up with yourself, right?
Yes,
is that correct?
Yes.
So that is what works in your favor. Like I said, the trademark law protects the prior user. So if we can prove to the court or to the trademark office that yes, we started using the trademark before the copycat adopted the trademark, we would succeed. So now what all can we do? Assuming the other side has gotten a registration, we can file a rectification petition to have that registration removed from the registered or rectified, as we call it, right? That is one thing. If we know that the other party is also using the name Modocs for similar or related goods, we can also send a legal notice to them asking them to surrender their trademark registration, to cease use of the trademark, among other things. Assuming they respond favorably, we may want to enter into a settlement agreement with them where we tell them that, assuming you don't use the name Modox in the future, we will not initiate any dispute against you. Assuming they continue to use the trademark despite the receipt of the legal notice, or they don't respond to our legal notice, or they do not agree to cease using the trademark, we can always take them to the court. Because we would be able to show through your social media pages or through your website, through its archived pages or through invoices, that we started using Modox first in the market.
Got it. So
Right.
these handles, these domain do have a lot of relevance these
They
days.
do.
Okay.
Right.
So now I think ये एक ऐसा part है जो कि कोई भी person अपनी company new खोल रहा हो या second third company establish कर रहा हो, this is something which they will go through.
Right.
So I think this information will really help our viewers so that they can actually consult IPR. Do you think that before keeping a name also ये सारी research कर लेनी चाहिए?
Absolutely.
Rather than रखने के बाद,
Right.
you create a problem and then find solutions for it,
Right.
rather than do your due diligence first only. So
Correct.
an IPR lawyer should be involved before you finalize the company's name.
You're absolutely correct. The principle of prevention is better than cure applies directly to the IP law. What happens is that when you're adopting a trademark, you have to first see, as I said, you have to check whether it is distinctive, whether it is not descriptive, and whether it is not similar to a pre-existing party. Because if you are not complying with these principles that have been laid down by the trademark law, you cannot protect your trademark. That is one thing. Not being able to protect your trademark, like I said, is one thing. You can also get a legal notice for copying somebody else's trademark. You can also be taken to the court.
Absolutely.
Right? So how do you check whether this trademark is taken by somebody or not? We go on to the publicly available trademark databases to check whether there is any party that is using a similar name or not. That's number one. We go to the Ministry of Corporate Affairs portal to see whether there is a company name that is incorporating a same name, a similar or same name in their company name or not. We go through the public domain to see whether somebody is using a similar trademark or not before you've adopted your trademark. Because if we find a red flag in any of these spaces, we will, raise that flag to you and we will tell you that we should go for another trademark. A lot of times what happens is that clients come to me and tell me that they have done their due diligence because they know how to operate the trademark portal, but they don't know how to do it as well as we do, because there is a method to the madness. So they come to us and they tell us that, we've done our searches, we've done our due diligence, and we did not find anything similar. But what we tell them, because it is a prerequisite for us, we tell them that we will first do our own independent searches, because the way we do searches would be very different to the way you do the searches. And many times it has so happened that we have found directly conflicting marks which they weren't able to identify. Right? So we prevented them from entering into a future dispute. Unfortunately, many times clients come to us when they've already prepared their websites and they've already, paid money to the authorities for certifications like GST registration, for company incorporation, and that's when they find out that there is
or brand which
another
already
party
exists,
which goes by the similar name. Another thing that we see in the market is that people tell us that, there is this international entity, they are named X, Y, and Z. We want to copy their name because they are not present in India. But that is also not allowed, because what needs to be seen is whether before the date you adopted the trademark, whether that brand had any use or reputation in India. Even if they don't have any use, whether they had any reputation in India. I'll give you an example. So a prospective client came to us and they said they want to register the Cheesecake Factory. Through our searches, we found out the Cheesecake Factory already had registrations in India, but that is besides the matter. Even if they did not have registrations, because the Cheesecake Factory in the US is such a big brand, and because the Cheesecake Factory is a name that was commonly used in the Big Bang Theory series, and they are such a lot of viewers in India of the Big Bang Theory who would have necessarily known about Cheesecake Factory, assuming this woman would have registered Cheesecake Factory and assuming Cheesecake Factory would have gotten to know about it. Through evidence of reputation in India, through TV shows, series, they could have filed a suit against this woman. So you should always be wary of copying somebody's brand, whether it is in India or outside India, for foreign brands, the catch is that there should be pre-existing use or reputation in India. For example, Prius was not able to protect its trademark against one of the defendants because they were not able to show that before the adoption of the defendant's trademark, there was evidence of use or reputation of Prius in India. Right, but that does not give somebody a license to copy the trademark. I just say that, come up with your own unique trademark, because you never know what kind of evidence the other side would have. Right? For example, I'll also take an example of hotels. It's possible that there is a hotel chain which does not have any subsidiaries or any units in India, but there are a lot of Indians who would be going to that hotel. So if they are able to show that there is knowledge in India because Indian tourists are going to that hotel, and that knowledge predates the adoption of the dishonest trademark, then the owner of the dishonest trademark can be liable to legal consequences.
Got it.
Yeah.
So to our viewers, जितना हम लोग आजकल इंस्टाग्राम पे वास्तु कंसल्टेंट्स एंड एस्ट्रोलॉजर्स से इंस्पायर्ड हैं कि हम अपने कंपनी का नाम रखने से पहले न्यूमरोलॉजी कराते हैं, उतना ही आई गेस उससे ज़्यादा इम्पॉर्टेंट है एक IPR लॉयर को हायर करना एंड अपनी कंपनी के नेम, सोशल मीडिया हैंडल्स रखने से पहले, डोमेन नेम लेने से पहले वी कंसल्ट अ लॉयर सो दैट वी सेफगार्ड आवरसेल्व्स फ्रॉम एनी फ्यूचर लीगल हैसल्स. Which brings me to again asking you that we discussed trademarks, we discussed copyright law, we discussed the industrial design law, and just now you explained trademarks again, and we discussed patents also.
Right.
Is there anything to IPR which is left for us designers to know?
Right. In my mind, designers and interior designers, or in fact any business owner, should also be mindful of the trade secrets that they can protect. For example, if you have a list of vendors that you've curated yourself specifically, a list of vendors that offer competitive pricing, and you don't want that list to fall into the hands of your competitor so that you can exclusively deal with those specific vendors, then that becomes your trade secret. So any information that is not available in the public domain that gives you a competitive advantage can be protected as a trade secret. There is no registration for trade secrets as such. Trade secrets are protected through contracts such as non-disclosure agreements. So whenever you're working with your employees, you can enter into non-disclosure agreements so that they are not allowed to disclose that list to anyone else. And if you do end up finding out that they have breached the contract, you can always sue them for breach of contracts.
Which actually brings me, I was about to ask you this. I wanted to shift the direction of the podcast from being specific to clients, wherein they are, causing pain to us, to employees whom we hire. And probably, I'll take an example of my own studio. So we, in our studio on a daily basis, we develop designs. We are a team of creative people. Now, those designs are obviously property of my company.
Right.
Employees do leave the organization. Nobody is here to stick forever. Once they leave, it hasn't happened with me though, but I have seen with my friends, my colleagues, that, and even my colleagues who've been working in some other firm, they're not running their own studios.
Yeah.
What they've started to do is, they've started to put designs on their social media handles or probably their own small portfolio website, and they are not even giving credits to the company under which those designs were made.
Right.
They were always a part of that company.
Right.
Probably that particular project was single-handedly being monitored, run, designed by that person. But still, does that give them a right to not give credits? Because when that project was being designed, they were not doing it as a freelance.
Right.
They were not doing it probably under their own company name.
Right.
They were working under a company, and those designs were made by that company, but by this person, say my friend.
Right.
And now they would want to post that on their social media, which is fine. But without giving due credits, does it, is it a problem?
It is a very big problem. And thankfully, the copyright law has safeguards against it. Right? So as per the Indian copyright law, whenever an employee is coming up with a work that can be the subject matter of a copyright, assuming they are doing it during the course of employment or using the employer's resources, it is the employer who will own the copyright and not the employee. Even if the employee is the one who has come up with the entire plan during the course of employment, unless, of course, there is an agreement to the contrary. And mostly we don't usually have these agreements which give the copyright to the employees. So that means that the employer is the true copyright owner. Now, the copyright law says that it is the copyright owner who has the right to disseminate the copyrighted work, which means that if the employee is posting the image without authorization on their social media handles or using it on their own website, that amounts to copyright infringement, and the employer can actually send a legal notice to the employee or take them to the court. That is one thing. The second thing is that you asked me about not giving credits. So that becomes a secondary issue. Point is, even if they are giving credits, but they have not taken the requisite authorization from you to begin with, and that is also copyright infringement, because they cannot disseminate any information without any consent or without any written authorization. So that is what the general
important point.
That is what the general copyright law says. Of course, there are certain exceptions to the law of copyright where you're talking about fair use, right? Where if you're using it in a manner to not earn any money, that may come under the category of fair use. For example, if I'm going to my next employer and I'm telling them about the work that I did, then that may constitute fair use. But the fair use exception, to assess whether the fair use exception will apply, we'll have to see what exactly was the nature of use of the copyrighted
Putting
work.
up on social media. Say, for example, you've made a house and when you were working for a firm, and then you've put pictures of that house, whether it's exteriors or interiors, on your own social media handle. Where does this fall?
Without authorization, that would squarely fall under copyright infringement. But yes, we would have to look at the exact facts again to be able to comment upon whether we can rule out the exception of fair use or not. But yes, the general rule is that if the employee is posting the content on social media without the authorization of the employer, that is copyright infringement.
And what are the legal issues that employee can face? I mean, what happens after this?
Right. So
say a notice is sent.
Yeah, I'll actually come to another point. So it is very important to draw up the necessary contracts with your employees, right? So when you are onboarding them, have a proper employer-employee agreement, have them sign an NDA, a non-disclosure agreement. Tell them about the consequences of what will happen if they disseminate or use or modify your copyrighted work without consent. So a clear, detailed discussion can prevent this to begin with. But assuming the employee has violated your copyright, we will issue them a legal notice. Ideally, in most scenarios, the employees, after receiving the legal notice, at least in our experience, they back off. We seek a written undertaking from them demanding that they take down all the posts, all the infringing posts, or we have them undertake to stop misusing the copyrighted work, and they usually comply. So ideally, assuming they are ready to comply, have them sign a settlement undertaking, settlement agreement, to have them prevent them from doing this again. Right? Assuming they do not respond or assuming they are not ready to comply, then the next action would be to take them to the court. Right? The online portals, online social media pages also have a takedown mechanism where you can establish trademark infringement, copyright infringement, and have the post taken down. But for that you need to have sufficient proof to show ownership of your copyright, so
which is very easy in this case.
So that is also something that we do explore. When we do not see compliance from the employee, we also submit takedown notices. Now, whether the takedown notices work or not will depend on the social media company's discretion, because they'll have to look at what is the evidence that you're adducing.
See, Nayantara, whatever you've discussed till now, it's great knowledge.
Right.
And I am 100% sure that even people who belong to this field and have been practicing since past 20 years, and fortunately haven't encountered such issues in their life, they would be completely unaware related to the issues which we've discussed. But youngsters in today's time, and due to increase in competition in the market, due to social media as well, and due to clients doing, I would say, architect shopping on a regular basis, these issues would rise. I think जितने ये पहले होते थे उससे ज़्यादा अब होंगे. Also ट्रेडमार्क्स लेना, ये सब शायद बड़ी कंपनीज इस चीज में इन्वॉल्व होती थी, बट आज की डेट में एवरी पर्सन thinks of, and actually is also, of his or her own company as a startup, and these are certain formalities that person wants to get done. What stops them from doing this are the financial implications which are associated with getting into all of this. So briefly, I would not want to get involved in this topic deeply with you, but briefly, if for our viewers you could just explain that if somebody wants to get a trademark done for their own company, what is the cost involved in getting this done? And post this, we discussed about a couple of disputes which might arise, and having said that, all contracts are in place. If there is a copyright issue, what kind of, again, financially, what numbers are we looking at, both for trademarks and copyrights?
Right. So before I go into the tentative figures, what I would like to point out is what I've noticed in the market. In the market, there are many agencies, there are many non-experts, right? Lawyers who may not specialize in this field, or certain agencies that, provide a plethora of services, offer these services at dirt cheap rates. Right, but when you're getting something at a dirt cheap rate, you can understand that the quality of the work also is not going to be
Absolutely.
high. Right, so what we see in the market is that because people are trying to skimp on the cost, they go to these agencies or these non-experts, they end up getting a registration. But the problem is that the registration is not how it should look like, right? Which makes it or renders a registration susceptible to a cancellation action. I'll give you an example. For example, if you've gotten a trademark registration done for X, Y, Z, A and B services, but if you're only using the trademark for XY services, and if you're not intending on using it for the remaining services, your trademark registration can be susceptible to cancellation action. So what good is such a trademark that cannot protect you? Or what good is a copyright or a patent or a design registration that cannot protect you in the future? So costs, unfortunately, are thing that people focus heavily on. What they should realize is that the loss caused by getting non-expert advice is much more greater than the fee that you will end up paying to an expert, right?
So see, I understand. It's like an insurance,
Right.
You don't want the, that you get medically unfit and then you are able to use insurance, or you meet with an accident and then you are able to use your car insurance. But you do get yourself insured in both cases, medical and car. But legally, you are bound to do that. At least in car, you need to, I believe, third-party insurance is mandatory, and medical insurance also. Looking at the scenario these days, it's advisable to take medical insurance. But this is something people feel that we'll come out of it, or probably we'll walk our way out of it. Or probably they think कोई नहीं यार इतना तो इतना मुझे फीस नहीं मिल रही जितना मुझसे लॉयर ले जाएगा. So just to give idea on figures related to trademark, for example, what should be, because this is something very, very basic, which everybody needs to get done, whether it is just protecting, trademarking their name, their logo. In our case, I don't believe shape makes any sense, but definitely the name and logo is of importance and relevance. So what if I would like you to give some idea of costing behind this, so that people are not afraid, sometimes you don't even know that this is going to charge, a person is going to charge this much, and you don't even ask, and you just don't go for it.
Right. So what I'll do is, first I'll break down the government costs. Right, the costs that need to go to the government for one trademark, for one that is for one application, for one mark in one class. Right?
One application, one mark, one class. Okay.
So I'll break these three aspects as well. So like I said, a mark can be anything. It can be a name, it can be a logo, it can be a composition comprising of both. So any such combination or any name logo constitutes one trademark, right? Now, the most relevant class for an interior designer would be class 42. Because so all sorts of goods and services are defined or segregated into different classes. For example, mobile phones fall under class 9, ready-made apparel falls under class 25, restaurant services fall under class 43, interior design and architectural services fall under class 42. Assuming that you're going for a trademark registration for one mark in one class in class 42, if you are an individual or a sole proprietor or a startup or an MSME, the government fee that you will be paying will be 4,500 rupees. If you're not an individual, not a startup or an MSME, then the government fee that you will be paying would be 9,000 rupees. Now, to add to this will be the lawyer's fees, right? So it is very hard to define what a lawyer's fees may be.
That would depend on their expertise.
That would depend on their expertise, on the years of experience that they have,
Absolutely.
and the nature and kind of firm that you're approaching.
Got it.
So ideally, costs of filing a trademark application from a good law firm can range from anywhere between 5 to 15,000, depending on what kind of firm you're approaching. So that is the cost that you can look at, assuming that the trademark registration is a smooth process, right? Of course, some would charge for a pre-filing clearance search, like I said, because if somebody is doing their due diligence, if they are putting the man hours, right, there would be an additional cost for that. Again, that is very subjective because that is what boils down to the professional fee. But if you're strictly looking at registration, you can, if you are a startup or an MSME, you can, deserve 9 to 10K for filing a trademark application.
And probably
through a good
this
lawyer.
being a one-time cost, I think this much.
So trademarks are valid for a period of 10 years, right? So once 10 years from the date of application have elapsed, and assuming you've gotten the registration, you can renew the registration by paying a certain fee for another period of 10 years. So trademarks can be renewed indefinitely. Copyrights, on the other hand, are a cheaper IP, because assuming if you're filing an application for an artistic work, for one artistic work, the government fee will be 500 rupees, assuming that it cannot also be used as a trademark, right? For example, I'll take the packaging of lace packet, right? That can constitute a trade dress, that can also constitute an artistic work. So assuming Lays wanted to copyright that, they would have to pay a fee of 2,000 because it can also serve as a brand, right? But for architects and interior designers, copyrights are a cheaper remedy, a cheaper IPR remedy, but that does not mean that copyrights can replace trademarks. Both have to be gotten depending on what you're offering. Designs, the government fee for designs again can range from 1 to 8,000 depending on what sort of entity it is.
Design as in we are...
industrial designs,
okay,
right? Like if I want to protect the unique features of this sculpture, right? The features that offer an aesthetic value so that nobody copies the same styling of this unique sculpture, of this unique statue, then I can register it under designs. The government fee will range from 1 to 8,000. I won't go into the specifics because it will get boring for our customers.
At least now we have an idea.
Not a huge sum that you have to incur.
Absolutely, I agree.
Right. So when you actually compare the cost of getting a good IP registration versus the cost of the losses that are caused,
absolutely,
they are humongous.
Makes sense now.
Yeah.
So Nayanthara, in our contracts, you've always been talking about contracts, the value of contracts, which play a great role in, protecting our IP as well. What, according to you, are certain points which, as an architect or a designer, we must include in our contract with respect to IP?
Right. So number one, you should clearly demarcate the authorship and the ownership of the copyrighted work. Like assuming if you're working on a project where multiple architects or multiple interior designers are involved, you should clearly demarcate the rights over your specific subject matter. You should also talk about the necessary licenses or assignments that you may want to execute, right? So you may want to specifically include that this IP is being licensed to only to you for this specific purpose. And if you use this particular IP beyond the agreed purpose, you will be liable for infringement or a dispute. You should always have a good indemnity clause, like we discussed. If you are being onboarded as a secondary architect and if the first architect ended up getting fired or ended up getting removed from the project, you want to indemnify yourself against a future dispute to which you may be subject to on account of a fault of the client. So that is something that you may want to include. You would want to include a good dispute resolution clause or an arbitration clause, as we call it, to see that the seat of arbitration is not something that is inconvenient to you. You should always
seat of arbitration.
So whenever there is a dispute, you go to an arbitrator, right? Or you go to 2 or 3 arbitrators as per the contract. Now you have to assess where will the arbitration happen. It should be at a location that is convenient to you both.
Okay.
Right? So the agreement
the
should not be
jurisdiction as in.
Right, the jurisdiction. So the agreement should not be onerous. There should be a adequate termination clause. What will be your rights and responsibilities, or what will be the other side's rights and responsibilities, assuming the agreement does end up getting terminated. So these are a few things out of a plethora of things that we need to cover in a contract.
Okay. So probably a lawyer like yourself
Right.
would be better able to draft such a contract.
Correct.
And then we can safeguard ourselves for any future legal
Correct.
issues.
I often see that people go on the internet and get these template contracts. But
बहुत
the
हैं
point
आजकल
is,
ऐसे
right,
बने हुए. Yeah.
the point is that these template contracts are not tailored to your needs.
Absolutely.
They can't factor in the intricacies of your specific relationship or the nature of transaction. Which is why, yes, it is always good to have a contract drawn up by a lawyer who is specializing in the field.
Got it.
Right? Because you also have to discuss the IP aspects. We a lot of times see that assignment agreements have been drawn up, but they don't factor in what the trademark law says, because the agreement was drawn up by a non-specialist who does not know what all needs to be included in the contract as per the trademark or the copyright law, or whichever law that is being dealt with.
True. Got it. We've discussed about so many aspects of IPR, but were these all limited to practicing in India? Again, I'm speaking only with respect to architecture interiors. Or, if we talk about exporting our services, how do laws change in that case? Probably, I'll give you an example. If I am doing a project in Dubai, so how do I protect my IP in this case?
Right. So the principles, the broad principles that I've discussed apply uniformly throughout the world, throughout the jurisdictions, right?
Okay.
But at the end of the day, each IP is territorial in nature, right? So if you have a protection in India, does not mean that the protection will automatically extend to some other country, because IP rights are territorial in nature and you have to factor in what each law says. So for example, if you are going to Dubai and if you're working there and if you're offering your IP services over there, we'll have to look at the local laws. So what you have to do is that you have to be aware of what the local IP law says. What does the local IP law require out of you in order to protect yourself? So what you can do is either you can engage a local lawyer in that jurisdiction, but if you're working in multiple countries, it is best to have a local lawyer here in India who liaises with foreign IP lawyers, so that a global uniform strategy for protection of your IP is created. Because at the end of the day, it is possible that an adversary that you find here in India might also be an adversary against you in some other jurisdiction, and that is something that we commonly see when we are dealing with bigger companies who are operating outside of India as well. So, in short, whenever you're going outside of India, you have to be mindful of the same principles that you are aware of in India. You can't copy somebody else's trademark. Your trademark needs to be unique, or your IP, be it a copyright or a design, that has to be novel. It has to be original. You will have to look at the local law, whether it allows you to seek a copyright registration in that jurisdiction or not. For example, in India, foreign IP holders are allowed to seek protection of their IP in India. Many countries don't have a specific registration for copyright, right? So you will have to see whether do you have to undergo a copyright registration over there. You will have to have your contracts vetted by a local lawyer over there to see whether you are being adequately protected in that foreign jurisdiction or not. So the principles are uniform, but yes, we do have to look at the intricacies of each country's own laws.
Okay. थोड़ा सा अपनी कॉन्वर्सेशन को शिफ्ट करते हैं,
Right.
टुवर्ड्स टेक्नोलॉजी लाते हैं. we are in the age of AI, and there are certain designs probably अभी बहुत कम है ऐसा कि AI is actually producing designs in our studio. But in future, and that future is probably 2 or 4 years from today.
Right.
बहुत दूर की बात नहीं है ये. If designs are produced by computers, by AI, what kind of protection do you think architects would have against producing such designs? Or do you think it's still a gray area?
So there are 3 or 4 things that we would need to discuss to answer this question, right? Number 1, the copyright law says that, and I'm paraphrasing, an author is somebody who, an author is the first owner of the copyright unless the author has, transferred the right to somebody else to own the copyright. So an author is anyone who creates the work or who causes the work to be created through a computer program, right? If I'm not wrong, that is what the copyright law says. I think it uses the word computer program, but we can always go back to it, right? Which means that if you are using any technological tools to generate your copyrighted work, you are the author. Now, the catch with AI is, and if you remember, I spoke about this, the work has to be original. So if you're using a tool like AutoCAD, I believe, there is an originality which you can prove because you're only using the technical aspects to arrive at a render, right? But if you are using an AI, right, an AI model, the question is whether the work is original or not. Because most AI tools like ChatGPT, for example, crowdsource the information from multiple resources. So if you are able to show to the court that you added enough prompts of your own to arrive at that work, and if you can show to the court that the final render does not have elements picked up by the AI from other copyrighted works, you may be able to enforce your copyright in that particular render. But if you are not able to show that you've added enough prompts, and if it turns out that the final render created by the AI is substantially similar, because that is the term actually that we use in copyright, is substantially similar to another copyrighted work, you would not have copyright protection over it. In fact, you might get sued for copyright infringement as well. The law right now, unfortunately, does not specifically talk about AI, which is why I believe that the law is still grey. And even if we look at the publicly available information, the consensus out there is that the copyright law needs to amend so as to factor in such kind of developments. In fact, there's an example which I wanted to discuss. So this is vis-a-vis whether you can claim protection in a work that is generated through an AI tool or not. There are various factors that you have to look at, like I just discussed. The second question that usually arises is, assuming that a work is created, who will be the owner of the copyright? Will it be you, that is the person who has fed in the prompts, or will it be the AI model? So the copyright law says that the copyright law uses the term any person. So any person can be a natural person like you and me, or it can be a juristic person like a company. But the copyright law does not define, or any law does not define a person to be an AI model. So there have been people who have tried to, make the AI tool the copyright owner, but that has actually been frowned upon in India. Somebody had gotten a copyright registration in the name of an AI tool, but eventually the Copyright Office issued a notice of withdrawal of that registration. So that is a secondary issue, but the main issue that the architects and the interior designers would be concerned about is whether the work that you have created using a tool, whether it is original or not.
Just out of interest, मैं इसी से related technology से related ही पूछना चाहता हूँ, though it does not have much relevance with architecture interior. Actually it does, because I'm basically talking about gaming.
Right.
अगर एक game develop होती है, उसके अंदर there are a lot of buildings which usually these gamers plan within that game. If those buildings are actual buildings,
right,
say somebody is using a building of a very famous architect or a very famous, it's a a world renowned building, and they're using it in their cityscape. So is what legal issues can that game face, the developers of that game face?
So the copyright law enshrines a principle called freedom of panorama, right? It is called freedom of panorama. According to this principle, if a cinematograph film, and a game can be deemed to be a cinematograph film because it has audio and visuals, if a cinematograph film incorporates a permanently situated work of architecture coincidentally or in the background, that would not constitute copyright infringement. But notice the catch: it should be permanently situated, and the use should only be incidental, right? There should not be direct focus on it. For example, if there's a building right over here, and if we are panning the camera, and if we are able to see the building, we will be able to protect ourselves under the law of freedom of panorama. But yes, of course, we'll have to actually look at the visuals to see whether such use was incidental or not. Right. So technically, gamers are protected like that under the freedom of panorama. But another catch that comes to my mind is that the exterior of Taj Hotel is that image of the exterior of the Taj Hotel is registered as a trademark.
So Taj Mumbai, you're saying?
Yeah, Taj Mumbai.
Okay.
Right? That red and white building is that the image of the exterior is protected as a trademark. Now, the principle of freedom of panorama has been enshrined in the Copyright Act. We can find it in the Copyright Act, but not in the trademark law. So assuming if a game does include that image, to my mind, I think Taj would have a cause of action against such a gamer, because they could claim that they are infringing their trademark, right?
So they've trademarked the facade of the building.
They've trademarked the exterior of the building, yes.
Okay.
But the gamer, assuming in my mind, if they are able to prove that the use was minimal, right? The use was incidental, even though the trademark law does not talk about incidental use per se, they can claim, they can place reliance on the principle of de minimis non curat lex. It's a Latin phrase which means that the law does not concern itself with trifles. So if one can show that the use was very minimal, very incidental, then it is possible that they might also beat the suit for trademark infringement. But I would, wait to see such a dispute arising before the court before I can formally comment upon it.
So to simplify it is a dispute.
Right.
And it's
not with respect to copyrights per se, but what if something is trademarks? Because, what if something is trademarked? Because the freedom of panorama is not there in the Trademarks Act. The Trademark Act does give certain exceptions to infringement, but this principle technically is not enshrined in that law.
Okay. Got it. We are towards the end of the podcast.
Right.
And I would like you to briefly explain or enlighten our audience of if there are any platforms or any sources which they can refer time to time so that their IP is protected, basically to gain knowledge on the subject even more. If you could discuss about certain platforms.
So while I'm not aware of any specific platforms that specifically target IPs vis-a-vis interior designers or architects, it is always good to read about the laws that are out there. It is good to read articles that are posted online that may be targeted to architects or interior designers. So while there may not be a specific platform, there are a plethora of articles that focus on the IP rights of architects and interior designers. So yes, it is good to get your basic information by reading up online. But like how you won't diagnose yourself by going on WebMD, my recommendation to you would be that after you've gained your own personal knowledge, always go to an expert and have them formulate your legal strategy.
And according to you, what are the most common mistakes you've seen that architects have been doing repetitively or designers are doing repetitively?
Number one is copying, be it copying of a name, be it copying of a copyrighted work. People feel that they have the license to copy because they cannot see a specific registration or they are not aware of specific dispute. That is one thing. The second problem that we see is that people don't want to enforce their rights, right? So, for example, if there is an architect or an interior designer who knows that his work is being copied by a competitor, they may sometimes feel that this competitor is too small to cause actual damage. But that is an incorrect form of thinking, right? Because at the end of the day, even if your loyal customers are coming to you, there is always a new segment of customers that may not come to you and they may instead go to the infringer. Secondly, there is a loss of reputation that is involved. A person who is aware of your work may believe that this is a related party, and if the other competitor, that is the copycat, is not doing a good job, your reputation ends up getting damaged. So that is one. That is the second thing that we see. Thirdly, people are not monitoring for infringements enough. They are not on the lookout, right? To see whether their IP is being copied or not. So that is a problem. Fourth thing would be not reducing your communication to writing, not entering into specific agreements that safeguard you as per your needs.
So Nayantara, we have a very interesting round at the end of the podcast. It's not like a coffee with Karan, rapid fire, but it's like more like a straight from the heart round. So I would be asking you 4-5 questions. So you could be as quick as possible.
Right.
So are we ready? Should we start?
Yes, we are.
Okay. What is your favorite architectural landmark?
Okay. So my favorite architectural landmark would be the Vatican museums that are there in Italy. I had an opportunity to visit them in 2023. And the hype about the Sistine Chapel is absolutely real. I got to see the fresco, Michelangelo's fresco, which depicts the creation of Adam. And I stood there for 10 minutes straight just gazing at the frescoes. So I think that has to be my favorite architectural landmark. And what I really like about the Vatican City is that they don't allow you to click photos, right? So although technically the copyright has passed on, right? The copyright does not subsist, but they are still protecting the value of their intellectual property, which technically they do not own, and they are doing their best to safeguard that beautiful fresco that they have created, because flash also damages these fresco paintings.
Yeah, and Europe always has amazed me as well.
Right.
So that's a great example. What's the most unusual or surprising idea that you've come across that someone tried to patent?
Right.
May not be your personal case. Probably you read on the net.
Right. I can't discuss my personal cases anyway. But the World Intellectual Property Organization, or WIPO as we call it, releases this list of wonderful and weird patents. Right. So I once came across this patent that basically protected a shark suit. So it is a rubber suit which has spikes on it, and it protects you against shark bites. Now, I don't know whether this patent has been monetized and whether this suit is available in the market or not, but it would be interesting to see how would somebody put on this suit without hurting themselves.
Right.
And how many units would it have sold, assuming it were monopolized or monetized, sorry.
That's interesting.
Yeah.
As a lawyer, if you could give one piece of advice to an architect or designer in a single line, what would it be?
Reduce all of your communications to writing, because there is so much scope for copyright infringement in your industry, and you need to correctly establish ownership of your artistic works. Reduce your communications to writing. The best way to do is to enter into a contract, but if you can't enter into a contract, record your communications through messages or preferably emails.
Spot on. That's gold. That advice is gold.
Right.
What's one common myth about IPR that you'd like to bust for our listeners?
That you can copy somebody's IP if it is not registered. So this specifically applies to trademarks and copyrights. For patent and design protection, registration is mandatory, but for trademarks and copyrights, it's not. So that doesn't mean that you go and copy somebody's IP if it's not registered.
Got it. And that was very well explained in the podcast as well, how we can deal with such a situation.
Right.
If you had to create a tagline for IPR awareness for the design industry, what would it be?
Just like your architectural works, your IP protection strategy should be unique and created according to your needs.
True.
Yeah.
Thank you so much, Nayantara. It was actually wonderful to have you. I guess till date, this is one of the best podcasts I've had, and I can say that on the camera. There was so much to learn. And for all our viewers who've been hooked to this podcast from past 1.5 2 hours, I think each and everything which Nayantara has guided us today, just rewind the video, stop, take notes, and then incorporate whatever you feel at whatever stage you are. And definitely consult a professional. Like we want people to consult us when we are designing homes. We always say that people should not start designing their homes on their own. They should consult a professional. They will save on costs. They will actually end up spending more money if they don't hire the right consultants, because we can actually guide them in the right way how things are done. Similarly, we as consultants should be aware that we too need to consult other consultants for running our business, because architecture and interiors is not just about creativity, it's also bounded by certain laws. And when we own our own practice, when we do our own practice, there will be issues periodically which would come up, and we need to safeguard ourselves and have knowledge to safeguard ourselves on those issues. So thank you once again, Nayantara, for being on the show. And I would love to have you on the show, probably as an extension to IPR, because you're an expert on IPR, or probably on some other topic. Thank you so much.
Thank you so much, Chirag. Thank you for having me over and, summarizing my advice so succinctly.